Now, every Thursday, we purpose to have a conversation around justice and access to justice. We call it Justice Thursdays. Today, we are going to talk about the Environment and Land Court and how the judiciary has been working with this court to ensure that there is access to justice on matters of environment and land. The Honorable Justice Lucy Mbugua is from this court, and she's the head of the Land Division. Good morning, Your Ladyship.
Good morning.
Welcome to Kenya's biggest conversation. That's the hot seat of the Situation Room.
Thank you very much.
Yeah, how does it feel now not being on the bench?
It feels okay.
You're not in the dock, though.
Yes,
Don't
I'm
worry.
not in the dock. Yes.
It's a lovely place to be.
That is true.
Karibu sana. Well, tell us about the court and what you've been doing. We know that you recently, last year, you commemorated 10 years as a court, when the court was elevated to a superior court by the Constitution, and what you've done so far and the work that you've been doing. But to welcome you to the conversation, C.T. Muga has the day's proverb. Every week he brings us proverbs from a different country. This week,
yes, our proverbs for this week are from the Federal Republic of Somalia. I mean, we refer to it as Somalia with great familiarity. Federal Republic, whose capital is Mogadishu.
right.
The proverb of the day is an interesting one. Justice, we will want you to tell us what you think of it and your interpretation. It's a fairly simple proverb. Women look for a lost camel in their bosom.
Women look for
A lost camel in their bosom.
what could that be?
You first reference the proverb to the country it's coming from. If you come from a community where there are no camels, this would not make any sense because you don't understand what they're talking
Yes,
about.
I'm from the mountains.
Yes. Now, why would someone look for a camel? Because they can't find it. And
What is the size of a camel?
it's a massive animal.
It's a very
Right.
massive animal.
Yes, very irregularly built. Okay. It's actually a very interesting. If you look at a camel and the way it's built, it's all over the place.
Yeah.
So why is it that someone would look for a camel in their bosom? That's why this is a proverb.
You tell me.
Justice, what you've said to me warms my heart. I'd like a situation where when I come to your court, you tell me what you think.
like.
What you like.
That is true. That is true.
And I will immediately tell you what I would like.
Yes, yes.
Think of a situation where something as big and as difficult to lose as a camel gets lost. I think the writers of this proverb were referring to someone will look for this camel even in the most unlikely of places.
That is so true. Yes.
Because this is something valuable. And also says that women will go into details that men would ordinarily not go
Not
into.
go there.
Yes.
That is true.
That is my thinking.
Yes.
Yes.
I hold-
Atakutafutia kesi.
Yes.
Mpaka mahali hakuna kesi.
Very true.
Okay. So,
You agree?
Make sense?
That makes sense.
Thank you.
That makes sense. Yes.
Judge, welcome.
Yes. Okay, thank you.
Now, the Environment and Land Court is a superior court.
Yes.
First of all, for those who are joining the conversation for the first time and they've never heard of this before, tell us about it. What do you do, and what does it mean when we say that it's a superior court?
This court was established after the promulgation of the 2010 Constitution. And it was because of a desperate need. Kenyans wanted a specialized court to handle the land matters. The issue of environment was not so prominent that time because the problem of land matters was deep. Historical background is that there was a tribunal which used to handle land matters there before, the Land Disputes Tribunal. For one reason or another, there were also issues of the statutes, which were Kenya's. I can say that the statutes sort of had a problem. For instance, the main Registration Act, that is Cap 300, the Registered Land Act, had a provision that a first registration was sacrosanct it was very difficult to challenge such a title. So generally, everyone wanted that title, that piece of land with a title, and they would go to any lengths to have it. But the land matters were mixed with other matters, criminal matters, election matters, procurement matters, children's matters. So they were not given the attention they deserved. And by the time we were having the constitution, the 2010 Kenyan constitution, that need was felt. And so the old laws were repealed, new laws came about, and with that, the Environment and Land Court Act was also born. And this is the one which gave birth to the specialized court, that is the Environment and Land Court, which came about in year 2011. But the judges, the first judges were appointed in October year 2012. There were only 15. So the issue that they were grappling with at that time was the issue of backlog. And it was big because the cases were very many, very few judges. But the expectation of Kenyans is that these cases will be handled now by the specialized court. So at that point, the primary concern was for the land matters to be handled expeditiously. Although the court was the Environment and Land Court, the disputes that were given attention at that time were the land matters. So as years went by and the courts were able to resolve many of these cases, the need to have now the specialized division for land and a specialized division for environment came about. So we have been working on this in the background until this year, when eventually the divisions took off on 1st of July this year, such that now cases being filed specifically have to be filed as either land matters or environment matters.
Okay.
If they are filed as environment matters, they'll be registered separately, they will be handled separately, they'll be fast-tracked separately. The same case to land matters. They'll now be filed separately. No one will be queuing after another in a mixed manner. Each one will be on their own. So the dedicated division will be able now to handle the land matters without thinking of environment matters. Yes.
Okay.
Does that mean, sorry, Ndu, does that mean that the judges will also be dealing, so if it's in the land division,
Yes.
you only have specific judges who are in the land division, and you also have specific judges in the environment division?
The division is operational in the entire country, such that in each court station, environment and land court, there will be the e-filing system or the filing system or the registration of matters will specifically refer to a land matter or an environment and planning matter in each and every court station, be it Kisumu, be it Kerugoya, wherever. But now for Nairobi, because the Nairobi, we are many, we are 8 judges, we have been able now to divide ourselves into judges who will be in the land division and the ones who will be in the environment and land division, such that for us in Milimani, we shall not be crossing over.
Okay.
You'll just be dedicated to handle those matters. But because of the shortage of judges in the other stations, although those divisions will be there, the cases will be registered separately, the judges will handle the matters together. For instance, in many of our court stations, which are 37, we have one judge in a court station. So that judge will be able to handle both the land matters and environment matters, but they'll be able to track. They can see how many cases have been filed, how many cases have been resolved in each division.
Okay.
Yes.
Okay. I know you mentioned, land cases were lumped up with every other case, criminal cases, etc., etc. So that was why then there was the need to separate them from anyone else. Was there anything else that then required a further specialization of this court to say that? What else were the reasons that guided, aside from it being lumped with everything else? Was there a trend, or were there, specificities that you saw about land cases that could not, that the courts or that the system saw about these land cases that could not actually be adjudicated in a normal court?
Yes. What happened is that before the inauguration of the 2010 Constitution, there was a tribunal called the Land Disputes Tribunal Act. It used to handle disputes concerning occupation of land, trespass to land, division of land, generally that. But what happened is that the tribunals would go ahead and deal with title to land, which was not in their jurisdiction. So for decades, that issue caused a lot of problem, because they would deal with, and in many areas of the country, people have titles.
Yep.
So when you encroach on my land, it's not just about occupation. It's about my rights, my absolute rights to that portion of land. So what would happen is that after the disputes were heard by the tribunals, that would not be the end. That would spill over eventually to the High Court as judicial review matters, as fresh matters. So sort of these cases did not have a finality. They kept on mutating, they would resurrect, and they would have no end. So people were just going round and round, and by the time of the year 2010, now it was like a crisis, because cases were there for cases which are 30 years old, 20 years old, and there is no proper forum where you can now litigate your issues, your land disputes. So that was the background upon which that court came to be born.
Okay. Do you see then the overlap?
Yes.
Even in this specialized court, do you see an overlap of cases of criminality? And then you have to deal with that. So you're dealing with a land dispute, but then also dealing with issues of criminality. Do you refer that to another court if the overlap happens, or is that all handled within these courts?
No.
Okay.
That one, there's no problem at all. The Environment and Land Court does not deal with criminal matters.
Even if it is a land dispute?
What happens is that land matters, somehow they are connected with criminal cases, especially where there are conflicts of great magnitude, where there are assaults. They manifest themselves in form of grievance harm, even murder cases, especially where historical land injustices have been prevalent. But now a criminal case will go to the magistrate's court, and it will be dealt there, while the portion of the land issue will come to the land court.
In the same case?
It's connected. It's the same case. Yes.
Okay.
Yes.
That's interesting that they would split them.
Yes. They are split.
Okay.
Yes.
Given the number of courts that we have dealing with this very sensitive matter, from the discussion we had with Justice Angote, your courts are overwhelmed.
That is true.
And he also told us how it is you are doing everything that is humanly possible to ensure that these matters are resolved and that the backlog is eased tremendously.
Yes.
But even as you deal with all this, what would you say are the most common cases that come to your docket?
It depends on the region.
Yes.
If you go to coast, they have peculiar disputes of houses without land. Yes, they are owners of the land, but they are absent people.
Absentee landlord.
They disappeared, they went away, they are not around. So, and the people who are there, they have built, they have developments. So they are very peculiar disputes. If you come to Nairobi, we have even cases of informal settlements,
Right.
where people have invaded land which is owned privately, and the disputes incidentally concern an invader against an invader, not the rightful owner. Two invaders before you.
Right.
And the actual owner of the land is not in the matter, they are not in the picture. So that is very, very peculiar. If you go to some other regions where there are no titles, there are very deep disputes concerning adjudication process. They are still trying to determine the rights and interest in land in the customary setup, yet we no longer have that customary setup in those areas because you know your land, you know your individual land, but you don't have the paper trail as at now. So adjudication process is still taking place. We have now other places where it's land buying companies. Land buying companies bought a lot of land like Ebakasi Ranching, Boyi Committee, and such ranching companies.
Yeah.
So they divided the land, but they never, the rights and interests never transitioned completely to the rightful owners. So other officials come and you know what happens. So these disputes sort of do not end. So at any given place, they are peculiar kind of disputes. Other places, it's issues of conversion of land from one titling system to another titling system. For instance, the conversion from an act, a statute called the Registered Titles Act to Registered Land Act. Registration of Titles Act to Registered Land Act. So that conversion from one regime to another, your rights and interests somehow can disappear.
Explain that. What are those two acts? What are those two regimes?
There is a regime of registration called RTA. That is the Registration of Titles Act, Cap 281. All of them are repealed. And the other famous one was Cap 300, the Registered Land Act. So for one reason or another, in some areas there could be conversion of land from that RTA to RLA.
But both are repealed. Why are you converting from one?
You know, we are handling disputes of yesteryears, not now. So we are unraveling how that transfer happened.
Okay.
So the disputes now are with us. They have not yet been resolved. So even if those statutes were repealed, the disputes remained. They have to be resolved.
And so what statutes do you use when you are addressing these disputes?
We have to address all of them. We have to use all these statutes because when the dispute arose or when the event arose, the statute that was operational at that time is that one which was repealed. It's not the Land Registration Act. That one now is the main statute governing registration of land. But what happens is that now if you hold a title under the former Cap 300 or the former Cap 281, you are supposed to take it to the land registry so that now it is registered under the new regime, the Land Registration Act.
What was the difference between those two previous ones? The Registration of Titles Act and the Registration of Land Act. What was the difference?
The difference is that for the RTA Cap 281, it was primarily in town, in cities, like Nairobi.
In urban areas.
Yeah, urban areas. Though it's a huge, maybe even you own those titles. It's a huge document. It even has a ribbon somewhere.
Yes,
it does.
Those ones.
And there are leases, mostly leaseholds of 99 years.
And there's all this documentation of who, what, when.
And the transfer, is captured there at the back. If I sell to you, it will be captured. Now the transfer there at the back. But for Cap 300, the Registered Land Act, this one was the absolute the absolute title.
Freehold.
The freehold, mostly in agricultural areas, but you can still find them even in some places in town. Some places in town were still converted. This one was the most precious one because it's absolute. It's completely
There's nothing
freehold.
about paying.
Yes, you don't pay things to the government.
Yeah.
It's yours absolute. Yes.
So the conversion here, then I'd assume, would happen from the RLA to RTA.
From RTA. It was
People converting from this commercial leasehold to freehold.
Yes.
I see.
Yes.
Wanting to become
You know now
unencumbered.
the CAP 300 it was more precious because it has no encumbrances. Yes.
Land disputes take time to adjudicate.
Yes.
Why?
I would say one, it's because of the complex nature of those cases. They are not just the simple cases that you can handle. And also land is very emotive and very precious. So everyone wants that piece of land through any means, including fraud. So even people who are not entitled to a piece of land, they still want that piece of land through any means. So when they come to court, they'll try as much as possible to convolute the dispute so that eventually they get that land. Also, I would say even the politics of the day would play a role, because where you had somebody who was, somebody famous, perhaps in the government, they would ensure that these issues are fast-tracked, the issues of titling, and people would get titles. But where people are laid back, or they were not, their presence was not so felt in the regime of the day, they were left behind.
Yeah.
Yes.
In the recent past, there's a matter that has been in the headlines for a long time, this one of Shakahola.
Yes.
And some of the headlines that we in the media have written, I thought I understood until we had an MP from that area talking to us yesterday about that same land. The headlines that I saw were government land. That Shakahola was in government land. And then the Member of Parliament for Kilifi North, Shakahola is not in his constituency, Shakahola is in Magarini, said, but it is community land. Now, this is where the confusion comes in my mind.
Yes.
At what point is community land, and what does community land mean? When people say this is community land, what do they mean? And when you say this is government land, what do you mean?
Yes. So community land and public government land is defined in the Constitution of Kenya. Community land is that land which belongs to a particular community, and the community is defined by the particular something that they have in common, like ancestry, and they occupy a particular portion of land for decades, ages. So, but now the problem is that sometimes it's not well demarcated. Sometimes it's not clear when you say community, which community. Sometimes there's overlapping of clans, and because of that, sometimes people take advantage of that lacuna, that vacuum, and they can infringe on community land rights. So that is why community land is like open access. Anyone can walk in and claim that land. So that is the thing with community land. But in an ideal situation, a community is supposed to be the owner and in control of that particular portion of land. But currently, community land is supposed to be registered. That registration process has taken long. There's a Community Land Act which came about in 2016, I think 2016. But the process of registering those community lands have been very, very slow. For reasons I do not know.
What's the place of the National Land Commission in all this?
The National Land Commission was supposed to be at the forefront of ensuring that those community lands were registered. Very few. I think I've only had 2, but I'm not sure about the actual number.
The actual progress.
Yes, the actual progress.
Like you've said,
yes.
The Constitution defines the different types of land.
Yes.
Chapter 5, land and environment.
Yes.
Land is categorized as public land, private land,
and
community land.
Community land, yes.
So for avoidance of doubts, there is nothing like government land.
Public land is government land. There is public land.
Explain.
This is land which has not been alienated. Land which has not been claimed by community, land which does not belong to a private person. That land belongs to the government. So it is what we call public land. And the title is supposed to be with the government. And it is all over, even in towns, in the villages, that land is there. But it's supposed to be properly demarcated because it's prone to grabbing.
Yep.
In fact, over the ages, that was the main problem. That any land which was open, just there, open, looking open, it's as if it was something wrong to have land which is just lying there. And it was prone to being grabbed.
Basically, it's like land belongs to the people of Kenya, right?
Yes.
And when we say there is public land,
Yes.
it is supposed to be managed or governed by the county government on behalf of the people.
Yes.
Right?
Yes.
And I've even seen that there is what can now be managed by the national government.
Yes.
Talk about minerals.
Yes.
Our uko chini kabisa sijui tectonic plates,
the
our
sea,
oceans and seas,
exclusive economic zones,
yes, forests and such.
Yes.
Those ones are the national government.
Yes.
But these are the county government should manage.
Yes.
Now let me ask the question.
Yes.
There is, for example, now an ongoing program by the government, both national and county, to develop affordable housing.
Yes.
And counties are identifying land in various parts of within the county where houses will be built and then people will buy those houses.
Yes.
When people buy those houses from the public, what are we doing? Are we transferring public land now to become private land?
A land can be alienated from it. The conversion can occur from public land to private land, even from community to private land, and vice versa, depending on the needs of the society at any given time. So that is why even from early ages, we used to have something called allotments. That is how many people acquired their plots in towns through allotments. That was conversion from public land to private land. So it doesn't mean that the process has stopped. It's only that now it's more transparent, more structured. It has an element of public participation. No, long time, you don't know how the allotment occurred. Somebody just got the allotment and they got a piece of land. But now there is that notion of public participation, openness, transparency, inclusiveness. That is why there is now interaction between the county government and the national government. Otherwise, it doesn't mean that the public land cannot be transferred to private citizens.
Can I just run ahead and see a matter that's being brought to your division?
Yes.
Where somebody says that MP so-and-so or county so-and-so decided to earmark this area for affordable housing, which basically means that we've transferred ownership of this land to private individuals who've bought the houses here.
Yes.
But there was no adequate procedure followed. Like you've said, there has to be a proper process of actually converting this.
Yes.
And this involves public participation.
Yes.
So we are saying that there should be proper public participation. By the time County X says this piece of land will be earmarked for this affordable housing project.
Yes.
There should be records in the county assembly showing.
A proper documentation process, something that can be traced, something real, not just imaginary where some notices are sent in some places where they cannot be seen. People have to actually know that this process is taking place. Yes.
Okay. I want to look at some scenarios where some of these cases that take time, based on what you've said, have been in court, land dispute for years, decades.
Yes.
And the principal in this matter is deceased.
Yes.
The children of the principal are getting well aged, but the case continues in court for whatever reason. What happens in the case where anybody contesting this dispute then ceases to exist by virtue of death?
What happens is that a process known as substitution takes place. So somebody has to go to another court, not the Environment and Land Court, but the High Court or the Magistrates Court, to get the document called the grant, the limited grant of letters of administration that enables them to step in the shoes of the deceased person as the legal representatives of that person. It will even be indicated in those letters of administration that the grant is for purposes of continuing with case number 123 of year 2005. So they step in the shoes of the deceased person. When they are litigating, when they get that document, they make an application before a court now to be substituted. We scrutinize that grant and we confirm indeed it has emanated from that other court, and they are now substituted. They will continue with the case as representatives of the deceased person, not as now the person themselves, such that in the final orders, when the final orders are given and they are in favor of the deceased person, let's say it's a case of adverse possession, so that claimant actually claims to be an adverse possessor of the land. Those rights or the judgment will be in favor of the estate of the deceased, so that the one who steps in the shoes of that person is not the actual beneficiary. He was only representing the deceased person. So because there could be even several children of the deceased.
The firstborn son is the one who got the grant.
So if you give orders in favor of that particular person, that is an injustice in itself.
Right.
So the orders will be in favor of the estate
of the deceased.
So they go and do now something called distribution through succession proceedings.
Okay.
Yes.
Another prickly situation is this whole business of ancestral land.
Yes.
The unspoken things that, may not necessarily have documentation, but the community knows that this land belongs to the family of. The children, the grandchildren have an understanding that no, you do not touch this because this is land passed down to the children of men, generations. But somebody starts to hive off the land and starts to sell.
Yes.
Right? Which happens often. A lot of those cases then come in. How do you adjudicate over matters like this? It's ancestral land. It's unspoken, but it's understood and accepted by everybody. In some cases, it is undocumented, but it has passed through generations. And the unspoken rule is that you don't sell ancestral land, isn't it? But it's being sold. And other people then come and build, or they plant, or they farm. And then we say, this cannot happen because it's ancestral land. How do you deal with that?
What I can say is that the customary tenure system was very, very clear that you held land for the benefit of the community members. So the community members had what you call user rights. They can use the land, they have access to it. And this issue of selling, having the land for purposes of selling it or using it as collateral to get money from the bank, that was something not as something unknown in the customary tenure system. So with the coming of the colonial way of handling land matters and the registration statutes, land became very precious. It was not just about user rights. You can use the land as an economic commodity to get a loan from the bank, to sell it and all that. So people became, let me say, greedy. The people who are supposed to hold the land in trust for their family members, they became greedy. For instance, if as people are registered as the owners of the land, they are supposed to hold that land in trust for the other family members. But once they got that title, they used it as their own land. And the jurisprudence that was emanating from court those yesteryears was in favor of the registered owners of the land. So many people are diffranchised by the legal regime of the day, the political regime of the day, and that is why there are very many fights. Because you can't just let that issue go like that. But now jurisprudence has changed somehow, and we hold that if land is ancestral, then it has the notion of both intergenerational equity and intergenerational equity, meaning that you hold the land for the people who are living at this particular moment and for the generations to come. They are supposed also to benefit.
Would you refund the individual who bought this land,
Yes.
whether it was ancestral or not,
Yes.
and they have put up a structure or they've begun something on this land? The court intervenes and says, no, we've said you must hold in trust
Yes.
because it's ancestral. Those who've brought the complaints
Yes.
then must be heard.
Yes.
But somebody else, party 3, has come in, they've bought, they've paid legally,
Yes,
they have
yes.
documentation. What happens?
It will depend on case-by-case basis. For instance, if now somebody has built on that land after purchasing it as a bona fide purchaser, you can tell the people to mediate on the issue such that now the one who was defranchised, they can be compensated. But it depends on case-by-case basis, such that you don't have to be very rigid and say that now the person who was supposed to benefit on this land must get it. Yet now it is in the hands of another person altogether.
But
we
Justice,
use, yes.
What often happens is you'll find in such cases there's an individual member of that family
Yes.
who sold the land to that individual.
Yes.
So the question that I often wonder is, when you buy land, don't you do due diligence?
And the question of due diligence now is very, very, very important.
Yes.
The courts have said and have pronounced in no uncertain terms that you must do due diligence. So if you go to buy land and you can see that it is inhabited, you can see some people with their hearts in, those cow pens in the homestead. Then you come to court and you say that I did a search, I found it was in the name of Eric, and that is why I bought it. The court will not buy that. The court will go deeper and inquire, yes, what kind of due diligence did you conduct? So how did you just go to the lands office and do a search? Did you go to the ground?
I did. And the person told me those are his people. And they are living.
How many houses did you see in that homestead? If the house, the place is owned by several people, you will see the houses, you will see the cow pens, you will see the way people divide their stretches of land. This one has planted coffee, the other one has their napier grass, and the land is actually divided as per each homestead. So how did you buy the whole land?
But Judge,
Yes.
when you talk about this ancestral land, I think just like you've said, ancestral land, pre-colonial, okay.
Yes.
Post-colonial, within the times of colonial, maybe.
Yes.
Nowadays,
Yes.
surely.
Yes.
If somebody is inheriting land
Yes.
from their father, that cannot necessarily be called ancestral land. Say today I bought a piece of land and I'm passing it on. Today, how many generations back do you have to go to actually qualify land as ancestral land?
We even have a very recent Supreme Court decision. It's called Isaac Kiebia case on that issue, which says that as long as you are able to prove that this is the family land, this is where your grandfather was buried, you know the Babu, you settle, you are on that land, although you have never owned a title relating to that land. You can be able to trace your roots to this land. Then you have rights that can be established in that land, such that you can prevent the other person from selling. I don't know how far we can go regarding this issue, because land goes diminishing. Sons keep on marrying, and their children will also get other children.
Babu subdivided the land. And actually allocated the land to his 5 sons. All right? One of those 5 sons is my father. Subdivided the land and sold some of it so that I can go to school. Right? Now I cannot go and start kicking out the person who was sold that land because Babu is buried in this bigger piece of land. I mean, that's what I'm saying. This becomes a very dicey issue.
It doesn't mean that the land cannot be sold. What we are saying is that you cannot differentiate other people who are entitled to that land. If Babu divided the land between his 5 sons
verbally, only verbally, kutoka hapa mpaka pale kwa ile mti ni yako, na wewe kwenda hivi kwa mto ni yako, nothing went to the land's registry,
as is usually the case.
That but now the succession has to be done so that now you divide the land properly. What you cannot do is now the one who is the one who has a title. Let's say, who has now the title? Is it your Babu? Or is it one of his sons?
Even Babu didn't have a title to this land. It was just, those lands. It ended up being.
Then that is land.
Remember, there are very many people who don't have titles.
Then that is land which we call land which has not been adjudicated. Meaning the rights and interests in that land have not been ascertained through the process of registration to transition from customary land tenure system to the individual tenure system. It's a very dicey situation, because even that land which has not been ascertained, people still sell it, people still grab it, people still use fraud, all sorts of things, bad things that happen to registered land still happen there. So that area is very, very, very murky, and the best thing is to have that land, that process of adjudication completed, so that people know their portion, their particular portion. So disputes still do arise, and it's up to the court to unravel the mystery. The mysteries are there, and they have to be unraveled by the courts.
Justice, you mentioned you want to, as a court, you want to be holding more and more engagements with the public. And you want them to get to understand your work more and more. My concern, even as we talk about it, is not the seller. That person probably needs money and whatever. It's the buyers. I still marvel. You go to a rural place, as you say correctly, you can see people live there. Someone tells you, I know it's we had our grandfather, but this was our portion. There is no documentation whatsoever, and somebody proceeds to buy and then proceeds to build. And I'm thinking, goodness, when other members of that family then come and start to look at that matter, you and your house, you can't take your house and take it somewhere else. It's a problem. Now, when you go about educating the public and getting them to know about your work, will you be going to rural areas as well, where some of these problems occur in abundance?
Our courts are spread in 37 court stations. So we are not just here in Nairobi. We are in almost every corner of Kenya. We are in Migori, we are even in Kilgoris, we are in Vihiga, we are in Kwale. So we are in all these places. And each court station will be doing its own thing. in engaging the members of the public to bring awareness regarding how to expedite both the land matters and environmental matters. So it's not an issue about Milimani alone. It is spread across the entire Kenya. Yes.
It's good to know.
Yes.
And it's good to know that the court is available across the country and accessible.
Yes.
And justice is now being served and delivered.
Yes.
Justice, we thank you very much for joining us today.
Okay.
Karibu tena
Thank
soon.
you very much. Thank you very much, Eric and Ndu and Muga. Yes. Okay.
Karibu tena. The Honorable Justice Lucy Mbugua, head of the Land Division of the Environment and Land Court, has been our guest this Justice Thursday.
This is the Situation Room, the only way to start your day.